Welcome. Thanks for joining. Just opening the waiting room here. Welcome, welcome. So, hello everyone. Thanks for joining us today. A warm welcome on this beautiful late summer day here at On Air, the online format of Swiss AI Weeks and Wildcard Media. And we are diving into the world of health today and have a session with the topic minimizing regulatory friction when designing health AI solutions. And today's guests are Thomas Kuster, partner at LEXR, and Aengus O'Donoghue, founder from Bensai Security. And as always, the session will be streamed on YouTube and can be watched later. And with that, I'm happy to pass over to Thomas.
Thank you, Sabine. And yeah, welcome also from my side. Looking forward to talking with you today about the topic of health AI solutions and the specific regulatory environment that these solutions operate in. Maybe first to the agenda, what will we talk about today? After a short intro and overview over the regulatory space, we will talk about specific medical regulations. We will talk about data protection and the health specifics of data protection. And we will talk about the relatively new still EU AI Act before we will have some time for questions. As Sabine said, I'm Thomas, I'm an attorney and partner at LEXR, advising a lot of AI companies, AI startups, and larger enterprises when it comes to integrating AI tools into their workflow, with also a specialty on sensitive data, including health. Aengus, maybe you want to say a few words on yourself as well?
Yeah, absolutely. Aengus O'Donoghue here. I've worked in security for the last 5 years. Privacy is definitely very close to my heart. Worked with Thomas and LEXR quite a bit across different clients. Looking forward to shedding some light in the sense of what I see on the security front too, on designing these solutions.
Thanks. Yeah, and the way we're gonna do this is I will be the boring part of today's call and talk about the dry theory of AI regulation, and then Aengus will translate it into something that you can hopefully use in practice on how to set up your solutions to reduce the regulatory friction. When we go to the regulatory environment, health AI is a bit specific in a specific spot. We have a lot of highly regulated spaces that all apply to health AI solutions. On one hand, we have medical regulation. The medical space is highly regulated. There are many medical specific types of regulation. We'll talk about medical devices today. We talk about the provision of medical services and some human research data as well. Data already there in the last word, but we also talk about data regulation, mainly GDPR and the Swiss FADP, so the classic data protection regulation, and the AI regulation that also overlaps. It's not all these fields overlap and have some things in common. You'll see that recurring topics like explainability and information security that come up in all these fields of regulation. Just for you, important to know when interact or building AI solutions in the health space, that you have a clear mapping of the regulations that apply to you, that you have a good overview and know where your solution is located. Why do you need to care about this? I mean, on one hand, to avoid fines, but actually in practice, especially with earlier stage solutions, it's less fines and it's more about sales enablement. So you need to understand the needs of your customers, or if you're a customer yourself, you need to understand what, like a customer, like a hospital, for example, you need to know what you can do and what you cannot do. Institutions usually care about risk mitigation, the reputation. They care about data protection and confidentiality and about internal compliance. And the service providers, the AI providers need to address these concerns of their customers in order to be able to sell. Because especially if they are not ready when approaching a customer, then this leads to extremely long procurement cycles, which obviously is a problem for many early stage companies. And then another reality that a lot of the AI providers are facing is the fast technological advancement and the fact that the legal environment is not always keeping up with the fast technological advancement, as we'll later see as well. Yes, and one issue that especially startups face, but generally artificial intelligence is a trust issue that a lot of larger customers, institutions, hospitals, and so on, especially in the health space or with sensitive data in general, have. It's simply a fact that a lot of these providers are not as trusted as more established companies. And one way to address this is to be really strict about compliance and really care about regulations. So the fact that you're here already is a good start if you're building an AI solution. That being said, let's jump to medical regulations, especially medical devices. This is probably the most important piece of medical regulation that applies to you. Medical devices are relatively a broad field. Of course, very often physical goods, but medical devices, this is important for you to take away. They include software or accessories like software that is accessory to a physical device as well. So physical and software combinations. Here, the most important thing for you is to establish whether you are a medical device or not. This is highly dependent on the intended purpose of your AI solution. As soon as you're in the field of diseases, injuries, or disabilities, you will most likely fall under the medical device sphere. Whether you're diagnosing or treating, you will fall under the medical device regulation, which comes with strict requirements. One way to get around this that we see a lot is that early stage companies tend to present themselves as addressing healthy people, not sick people. So and then also don't try to prevent specific sicknesses, but really just try to have healthy people lead a healthy life. So the classic well-being apps that are around well-being software. This is a sector that is not falling under the medical device. So if you're deciding after today that probably your AI should not be a medical device, there are ways to get around, but all these ways really depend on the way you present yourself on the market. So this is really also a marketing topic, and the topic where you have to really assess the user interface, the user flow, how customers interact with your software, and how you present yourself on the market. If you're like on the edge there, be sure to be very careful with marketing. If you're falling under the medical device regulation, you will have to undergo a risk classification. For software, typically, software is low risk, especially if you're storing, archiving, or just displaying health data. But as soon as it goes in diagnosis or therapy decisions, monitoring of specific health stats, then you are, and especially when it goes into guiding doctors in taking decisions or even autonomously taking decisions that have an impact on health, then you are falling under the moderate to high risk categories. This is important mainly because when you're falling in the class 1, the low risk category, you can do a self-assessment, relatively straightforward. if you're falling under the high-risk classes, you have to have an assessment by a recognized body. This is expensive. This is also time-consuming. There are service providers on the market that do this for you, but still, this takes time and effort. And yeah, the one problem that you'll face there as well is that you have to prove repeatability, reliability, and intended performance. You have to prove evidence or provide evidence that you're consistently delivering a compliant product. And this is, of course, difficult with AI, especially if it is self-learning. So if it's a tool that is continuously improving, or if you have a black box situation where it's like a probabilistic model where input and output, especially output, is not very repeatable, you might have an issue there. And currently it's questionable whether under the current Swiss legislation you can approve self-learning systems at all. Because, yeah, and in general, as soon as you're using probabilistic models, it's hard to prove repeatability and reliability. The same applies in the EU and also under the EU AI Act, not only under medical device regulation. You have to always, whenever you have a substantial change of your software, you have to conduct a new conformity assessment, which again is painful and expensive. But for example, in the US, there are at the moment suggestions that at least if the model is learning and improving itself, changing a pre-agreed plan, then you can have this approved, the whole plan, and don't have to, with every iteration cycle, you have to get a new conformity assessment. So maybe one point that was, I think, not said before, in case you have any questions, drop them in the chat and we'll take it up either on the go or directly after this presentation in the end. So this on medical device regulation. When we are talking about health AI, however, it's not the only relevant topic. I think almost more important and sometimes forgotten is the already existing regulation of health services. So the fact that doctors are regulated, hospitals are regulated, and this is a technology neutral regulation. So whenever a health AI or a software tool in general provides a service that is within the monopoly of doctors or hospitals, this AI or software needs to be applied by a doctor or hospital which is licensed. So you still have the duties of the personal duty of care. You have the professional education that needs to be there with the person using the software. And currently, most health tasks are simply not fully delegatable to AI because you need a doctor to provide most health services. One point that's probably worth highlighting and where AI can also help is one of the parts of the duty of care of a doctor is the documentation duty that a doctor has whenever they take a decision on based on medical grounds. They need to document this decision and what led to this decision. This can be a disadvantage of AI if traceability or explainability is not possible due to like a black box large language models, for example. But it can also be an advantage because if set up properly, such solutions can take the burden of documentation away from a doctor. I don't know, Aengus, do you have something to say on this one already, or?
No, I think that's pretty clear, and people often forget about this. So that's something that's been around for a while.
Yes, exactly. Then the next point that needs to be highlighted, telemedicine is still not legal in every canton. So this is still something whenever you're designing medical software solution, you also have to look into cantonal laws. Health laws are cantonal in Switzerland. And yeah, it might be that a good solution is not yet allowed just because, for example, with telemedicine, the provision of health services has to happen in person in many cantons, and in person is interpreted as not online, so physically in person. So whenever you're having a service that is mainly digital, this might prove an issue. One other regulation that I wanted to mention briefly is the Human Research Act. Really just quickly, this is covering research on human subjects, including personal data that is health related. If you're doing research or if you're collecting data for selling to research institutions later, for example, here you have a few points that you have to consider, mainly that you get informed consent from participants, and that pseudonymization or especially anonymization is strongly encouraged. I will not dive too deep into that, but if you're doing research in any way, Human Research Act is something you should care about. So in short, in health AI, you have various regulations that you have to consider just from the medical side, and this depends highly on what your AI is supposed to do. Most important is probably the regulation of health service providers as such, like doctors and hospitals, that still apply to AI. It doesn't matter that it's a software. It will always have to, like if it's in the monopoly field of a doctor, you will always have to have a doctor using the AI, and you cannot just replace the doctor by now if you're in that regulated area. And then also very important is the medical device regulation that governs every tool that is used somewhere in combination with sicknesses and diseases and injuries. More general, not medical specific, is data regulation. Here, when I speak of personal data, I'm speaking of data that is directly linked to an identifiable natural person. This can be a name or a video, like a picture, but it can also be an IP address, for example, that is linkable to a natural person. You then also have the concept of pseudonymization and anonymization of data. Pseudonymization is, for example, the IP address without the name attached to it is pseudonymized, but is still linkable to an identifiable natural person. So it is still considered personal data. Full anonymization means that the data is rendered in a manner that it is not retrievable. So it's not linkable anymore to a natural person, which is, especially in health, extremely difficult. Whenever you're using health data and you have more than just one or two parameters, you can typically link it back to a natural person. And full anonymization there is difficult unless you're doing aggregation and using larger data sets, including data points of multiple individuals, but typically very difficult. So when you're designing health AI, just assume that you're processing personal data unless you have a very good plan on how to get rid of it. One option that people discuss currently is using synthetic data. If you're taking synthetic data, make sure it's a trusted provider, and look that the provider can actually prove that the anonymization process works and that it's not personal data anymore. If you're using synthetic data and you can use it for your solution, it still fulfills the purpose. great, but make sure it's not personal data. But can be definitely a very good solution to many problems. From the moment personal data is processed, you will be subject to data protection laws. In Switzerland to the FADP, but very often, because you're probably using wider data sets, also the general, like the GDPR of the European Union. And what I will not distinguish between the two later on. They're really similar. There are some advantages of the pure FADP, but I will focus on, or I will also include GDPR in the assessment going forward. Here, it can really be everything, every personal information that makes it applicable to you. Of course, when focusing on health data, we're talking about sensitive information, sensitive data that will lead to stricter measurements that you have to fulfill. In general, though, you have to follow a few core principles when processing personal data: lawfulness, fairness, transparency. This is I think more or less self-explanatory. You have to limit yourself by a purpose. I will go into that a bit more in detail after, but basically you have to decide what you use the data for and then use it only for this purpose, not just store it to collect data and decide later on what you want to do with it. You need to minimize data. So whenever possible, don't use personal data. This goes also in the anonymization and synthetization of data. If possible, do that, but it's, as I said, it's not always possible. And then also very important is the integrity and accuracy of the data, as well as the topics of privacy by default and privacy by design, which Aengus, I think, will tell you a bit more about.
Yeah, exactly. So we've seen some of the core principles under the data protection umbrella in general right there. But how do we operationalize these in practice, right? The privacy, but also the security by design idea is that we bring these reviews or considerations into the beginning of the design stage of the product instead of reacting to them at the end or once deployments are already well on their way. Now, the shift left software deployment philosophy is still one of the most recommended frameworks to turn a company from a compliance reactive to a compliance proactive business, if you want to say so, especially for getting regulation, privacy, and security mandates in early on and not having to revise them later on. But what we wanted to highlight is that more often than not, product and engineering teams do not actually sit at the design table of a new feature or product where each can bring in legal, privacy, or security stakeholders to determine the guardrails that need to exist before a feature or a health AI solution application goes live. So when we think about any product that we use today, there's always the usability versus privacy or security trade-off that happens behind the scenes in a business function, like in a product realm or an engineering function sometimes too. My favorite example for like a trade-off here is me getting kicked out of my sessions all the time just because I chose to grab a coffee. So that's a very common conversation around when you develop a feature or an application, how much is privacy and security going to become a pain point to the end user or the consumption of the product. So therefore, if product and engineering functions do not come to an agreement on this before a new AI component gets to the technical implementation stage, what we see is that the late review friction that then starts at the engineering final stage creates a lot of delays, and sometimes worse even, it skips certain considerations or it ignores the entire security and privacy angle on why these features could possibly fail throughout its life cycle in general. One of the ways we actually see companies deploy faster while not overthinking the guardrails for the entire sort of customer base that is going to use the new feature or the AI function is through feature flag or canary deployments. What do I mean by that? I mean, basically, a newly designed AI feature or application does not need to be enrolled or rolled out to your most regulated customer or deployed to work on the most sensitive use cases from day one when you launch it, for the first time. So canary deployments or feature flags basically mean partial rollouts or phased rollouts, where you not only follow a better risk approach in terms of experimenting on how it's going, but it also allows companies to deploy a kill switch and test with your subset of users or possibly consent-given customers first. So you run generally less risk and a more controlled deployment strategy there. And that's it for some ideas on this.
Yes, thanks, Angus. Yeah, important also to say here, I mean, generally privacy and regulation as such is, yeah, it's usually risk-based. No one is fully compliant, and doing something is always better than doing nothing, but you will never be able to reach 100% compliance. So by applying some of the practices on the technical side that Angus just mentioned, you will be able to cover your risks quite well. And then on the legal side, you will also be able to cover them quite well by just following a few basic rules. And one of them is when you're transferring data further down the supply chain, when you receive data from a customer or like from a hospital, for example, even directly from a patient, and then transferring them further down the supply chain, you'll have to be A, sure about your role in this supply chain, and then B, make sure that the supply chain, the whole supply chain is covered by contracts. What do I mean by role? So privacy law decides between controllers and processors mainly, and then data subjects. Data subjects is the individual on whose data you're processing. The controller is the entity that decides why and how the personal data is processed. That person is also responsible for everything happening further down the supply chain, at least more or less. That is typically, yes, if you're if you're in a classical hospital or doctor setup, the doctor or hospital will be the controller. And then you have a processor. Processor is anyone who processes data on the controller's behalf. So if you're providing a device or an AI tool that is used in hospitals that assists hospitals in fulfilling their purpose, then you will be a processor. Whereas if you're having a health app that is downloadable and usable just from the app store, then you will most likely be a controller. And for example, AWS will be your processor if you're hosting your data on AWS. Sub-processors then are just any processors further down the supply chain. And this supply chain needs to be governed with contracts. They're usually called data processing agreements and govern limit the purpose, why the processor can process the data for what, where, what security measures they have to take, and so on. So this is really in securing the personal data, should keep the personal data safe, and should provide security to the data subject and also the controller on whose behalf all of that is happening. To look at that being said, I think it's really important as well that you're choosing your supply chain also downstream very carefully, and assess service providers that you want to integrate somewhere in your supply chain, because also as a processor, you're responsible for everyone you send data to when you're doing so on your own behalf. Aengus will now tell a bit more concretely what this means in the case of integration of large language models into your solutions.
Yeah, so we talked about the processing role your company takes, but also a bit about how you deploy and integrate your LLMs. And the integration choice has quite a large impact on how much regulatory friction and compliance burden is heading your way in general. And you can see in this slide there are usually three general ways AI companies or companies with AI components leverage AI and ultimately offer it to their customers. API cloud hosted and on-premise. First, the API approach, probably the quickest to implement. So generally, you're essentially just calling an OpenAI or Claude or another provider's API, which seems simple. But in reality, that can mean every patient record, for example, you send to that API is now a data transfer, right? So in Switzerland, for example, that means you need to ensure professional secrecy is maintained and have several other obligations on top of this. So therefore, it's not as simple as we thought. But also, how do you do that when OpenAI's terms explicitly, for example, exclude healthcare use cases? So it's quite risky. Or when the provider can technically access your prompts, which is also difficult to justify to a regulator or to an auditor. So this is where we see a lot of friction at the moment because companies realize too late that their quick API integration violates sort of several regulatory and also privacy laws under different regulation and medical confidentiality. But there's a second option, of course, here, which is the cloud-hosted solutions, which are split into two critical paths. In the service provider's environment, like, people might have heard of Azure OpenAI or AWS Bedrock. There's several solutions for the big cloud hosting providers where you get sort of very strong SOAs and possibly scaling functionality on top if you use the in-service environment for LLMs. And you're sending patient data to their infrastructure still. So you don't really control it 100% yourself, but that leads to a little less questions for sure and a little less scrutiny there. So the questions there, you can sort of reasonably, the question there is whether you can actually just reasonably guarantee that the cloud hosting provider directly cannot access your data, right? There's especially some concerns around the Cloud Act, where the US government, for example, can compel a cloud hosting provider to give them information on European-based or Swiss-based companies and patient data as an end user example there. But there's also option B here in this slide, which is where you're storing this in your cloud environment. So same provider, whether it's Azure or AWS or GCP, but you control the keys. So you encrypt and decrypt everything and the data itself, which is a mitigation to that argument on some level again, and a plan or option B. So here you shift then from sort of hoping that Azure, AWS, and Google follow your governance strategy or technically enforce this to you're actually enforcing this yourself and you're mitigating that by, for example, owning your own keys outside of the infrastructure and encrypting the data in general and decrypting the data in general yourself. And then there's the final option here, which is the on-prem or self-hosted option. I like to call that sometimes the more drastic or nuclear option, depending on the business model, but that gives you complete control, basically guaranteed data residency, depending, of course, on your general setup, because infrastructure is one component in an application. But this obviously on an on-premise level means that you'll have a thorough implementation to worry about, more or less specialized components or hardware you need to implement, certain expertise, of course, like required internally to set this up. And most importantly, you really don't have anyone to blame if anything goes wrong, but yourself. So it's on that implementation front, definitely, and an availability front, more of a risk factor than if you outsource this to someone who guarantees certain availability, SOAs, and data residency commitments to some degree.
And maybe just quickly to jump in here also from practice, negotiating contracts with hospitals, for example, for AI providers. API, you will not get that through in almost any case if there is health data involved. On-prem can be a solution, but not every hospital has the capabilities to host models directly on premise. Sometimes, the cloud hosting in the cloud environment of the hospital can be a viable option. And with a Swiss cloud provider, there you also have the chance, for example, as Swisscom is building up its capacities to run to run GPT 5.0, I think, as well within Switzerland, or then with Microsoft, for example, can also work. Can really speed up your deals if you're thinking about this early on. Yeah, going back to Aengus here.
Yeah. Either way, unless you're building something completely from scratch, which is relatively rare, you will have a vendor due diligence process that you're going to run as part of whatever cloud hosting provider setup or LLM you choose. And it's pretty strictly governed under regulation also these days, how you evaluate your vendors. And I think there's a couple of points here we want to call out specifically. So first, hosting options and tech stack compatibility. You need to understand exactly where your data will live. That's clear, but also how long is it retained for? Who has access to it? If I open a support ticket with Google on something infrastructure related, does that change the residency or the hosting for that data? If there's data involved there that is more sensitive, or PII, for example. But also, yes, on the tech stack compatibility, you have an existing system this needs to work with. The larger the company, the more complex this gets. Some hosting providers might not have regional deployments in certain regions. I think in Switzerland, for example, you won't find Google that is sitting in Germany. So if you have very strict Swiss data residency requirements, you'll have to communicate that up front when you deploy to that new customer. And generally, there are a lot of questions that you should be asking yourself before you make that decision as part of the vendor due diligence. But also, a point that a lot of companies ignore is sort of the second point here, which is subcontractor governance and boundaries that you have to mention and manage. So LLM providers often use multiple sub-processors or subcontractors, and you, as the controller or the person who directly engages with your customer, you're responsible for doing all of the diligence in that realm beyond just trusting the vendor like Google, Azure, or AWS directly. So you need to understand and clearly visualize the potential data flows within the cloud hosting provider or the LLM you choose. A lot of times we see that some newer AI companies and also some newer cloud hosting providers out there, they have their main region and their main functionality in a certain region, but then they use maybe some support tools or some logging tools or some CRM integrations that don't actually sit in that same region. So challenging them on exactly how the data flows run under the hood is something you should get into when you do that vendor due diligence, and that will avoid a lot of nervous sort of reaction to if one of the vendors you generally use and you've communicated to your customer that are in use have a breach or are potentially suffering from a security incident currently. The third one, I've mentioned this a little bit already, is the implementation effort in general. If you're doing an on-premise implementation, or if you're doing a self-hosted implementation in general, the technical evaluation is almost critical before you even make a decision which solutions to work with. And it will influence how you govern and manage security on an ongoing basis from a business operation point of view, of course, but also from a governance on security, privacy, and regulatory requirements. So bear that in mind when you choose a vendor. Don't get surprised after the fact. Yeah, and then last but not least, it's pretty common these days to ask for data flow diagrams, network diagrams, user experience diagrams when you are in your sales cycles or when you want to do business with larger companies. And a lot of the times I see startups in particular that have not really thought about just general data flows within their environment. And when they have to share something out, they share something very limited. And sometimes their customer prospect comes back and says, but you're DPA mentions 6 sub-processes. I don't see them anywhere here. I don't see any microservices in this data diagram. Are you telling me that they don't store any of this data, or did you not mention them in this diagram? So alignment here is pretty important, and having a general understanding on an ongoing basis where data goes to which microservice and when is going to get you much better answers in your procurement sales cycle.
Thanks. And just directly also addressing one of the questions in the chat, whether the vendor DD is different from hospital to hospital. Yes, it is difficult. I mean, obviously, depending on the country that you're selling to, but then also in Switzerland, depending on the canton, and within the canton, depending on the hospital. Reason for that is that public data protection laws are cantonal. So we have one data protection act that applies to whole Switzerland on the private side. But then when it comes to the public acts, you have cantonal data protection laws and cantonal data protection officers that have different standards that they apply. Hospitals as public institutions have to apply the standards or have to try to apply the standards that their data protection authorities set. And then also you have, in the end, you have different people running these assessments. It's not set in stone and in detail within the law how these assessments have to look like, but you have people that applied more diligence and less diligence. Some people, in my opinion, apply a bit too much diligence, and others are rather lenient. But also a lot of buyers, procurement teams in hospitals, they are also scared of doing mistakes here, which is understandable. But yeah, this leads to very different DD processes depending on the company depending on the hospital. But very often what you'll have to do is information security and data security assessment. So this is a rather standardized assessment that explains data flow and subcontractor governance especially, but also, yeah, that touches on most of the points that Aengus now mentioned. And yeah, how detailed they want this, again, depends on the hospital. Trying to speed it up here a bit so we still have time for questions in the end. One key aspect also that I wanted to talk about when it comes to AI training and fine-tuning is the legal basis that you need for every data processing. Here it's important to know, and that's the first really important thing, health data, especially like in the EU, not in Switzerland, but in the EU, it's generally prohibited to process health data unless you have an exception that is applicable. These exceptions are, it's a closed list of legal bases that you can apply for the processing. And there you have to distinguish between you have to differentiate based on the role that you're taking as a entity training in artificial intelligence. You might do so for a specific customer, like a hospital or a larger corporate or even an individual potentially. If you're doing so on behalf of that of someone else, you're a processor. Whatever you do will be processing based on contract, or not whatever you do, but the main purpose of it will be fulfilling a contract. This is fine as long as the controller has a sufficient legal basis. It's up to them to define this legal basis. When you're fine-tuning or training for yourself as a service provider, meaning you combine data sets of multiple hospitals, for example, or multiple doctors, patients from wherever, or if you're building your own system, then you cannot use contract. You will not be able to use legitimate interest as a basis, which is very often used for most processing activities of standard AI solutions. And you have to most likely rely on either consent, meaning explicit and informed consent of the people whose data you're processing. You need to inform them before collection, and they have to explicitly consent. So it cannot be just a hidden in the terms and conditions. It really has to be an informed consent. Or what you can do in certain circumstances is scientific research. This is possible, for example, if you're doing university partnerships, but it's also, this is a very gray area, and you'll have to have a few more cautionary measures in order to rely on scientific research. Definitely not something you should just decide without the proper legal assessment. This makes it rather difficult for AI companies to train and fine-tune models that they can then resell to other hospitals, for example. It is possible, but a bit burdensome when collecting the data. You have a few other legal bases that hospitals or doctors may use, but for the AI company, it's a bit difficult to apply them, mainly public interest and the purpose of providing medical services, because these are usually provided by the doctor or the hospital themselves, and the AI model or the AI provider that trains or fine-tunes the models cannot rely on them for themselves. They can do so when they're really just doing it to fulfill their contract with the hospital or doctor, but for themselves, this is difficult. So yeah, be a bit mindful about your legal basis when you're training on health data, especially health data of European citizens. Yeah, that being said, we're going deeper into EU regulation, the EU AI Act especially. Why not Swiss AI regulation? Simply because there is none so far, and there will be in the future, but right now the Federal Council just sits and waits and is drafting in the background, but for now, nothing out there in Switzerland. Just the mention that they want to regulate sector-specific and not a full AI regulation like the EU AI Act. The AI Act is often a bit misunderstood as a general regulation of use of all AI. This is, yeah, to some degree true, but in the end, it's more like a product regulation similar to the medical device regulation. Applicability depends on the geographical impact. So whenever your advice or like your AI is used with EU citizens, people in the EU, like physically in the EU, or sold to EU companies, for example, you have to care about it. If you're really just within Switzerland, not really important for you right now. Main concepts are that it distinguishes between different roles and responsibilities. Most important in most setups are the provider and the deployer persona. So that very briefly, the provider is the entity developing a system. The deployer is the one that uses it. This is, so if you're using ChatGPT within your company, you're the deployer, OpenAI is the provider. Yes. Then the AI Act is risk-based. So this means you'll have to look at the different risk categories. You have unacceptable risks, so prohibited practices. This is already in force right now. You have high risk. Here we have regulation coming into force in August next year. And then you have, yeah, some like general purpose AI models and lower minimal risk AI models that we will not talk about too much now, because medical devices are high risk and most medical use cases will be high risk use cases. Might differ if it's really just some basic assisting tasks that are more on the operational or organizational side, but usually if you're processing health data, you will be a high-risk AI tool. What does that mean? As a high-risk AI provider, you have quite strict regulations regarding risk management, regarding data quality, transparency, record keeping, accuracy, robustness, cybersecurity, and so on. And you'll probably see from what we what we discussed now in the past 50 minutes, that you're anyways, like if you're falling under the medical device regulation, especially, anyways have to fulfill most of these points. So this will not really rock the world of any medical device. As a deployer, for example, a hospital or a doctor using it, you also do have some responsibility, mainly that you use it in accordance with the instructions, meaning you cannot use ChatGPT for medical purposes because OpenAI instructs you not to. You have to ensure human oversight and yes, information transparency obligation, data quality check obligations as well. Yes, also maybe important to know is if you're using a AI system that is not intended for medical services, and adapted for medical services, building, for example, a custom GPT that provides medical advice, then you will be, like your role will shift from a deployer to a provider, and you will have to fulfill the provider obligations, which, yeah, not sure you want that. So maybe better buy a specialized tool. Yes, handing over to Aengus for some AI risk mitigation strategies.
Yeah, I think a lot of us have seen this already somewhere, but we wanted to also address some of the critical AI risk mitigation approaches that organizations, especially in healthcare, can take to just make the regulatory component and the compliance around it a lot less friction than if you didn't do these things, especially in high-risk systems. So I think the first one, a mandatory human-in-the-loop validation, this is pretty obvious. If you are using AI to diagnose patients or for certain treatment structures, I think we all agree it's a must do, a must review scenario for a doctor to not just fully trust the AI and its output and share that with the patient. On the second point here on the labeling of AI generated content, I think we've also seen this already with certain AI vendors we might use ourselves. It is just very, very much at the moment a trend to see what is actually AI produced in anything I consume, read, especially in the healthcare and diagnosis realm, because we want to be able to differentiate. A doctor also wants to be able to differentiate and show a patient what the diagnosis is and what parts of the diagnosis actually are clearly AI generated. And I think that also makes sense. It is a little bit more complex how this looks like on the technical level. And the AI providers are actively working on being as transparent as possible in this regard. The third one is the approach to deploy sort of medical specific LMs rather than just generic models. General purpose models lack the clinical training data sets, of course, like medical documentation and studies, and therefore the validation that healthcare sort of demands in this field. So I think that also makes sense. So a purpose-built medical model is always going to be one that is preferred or first considered in any high-risk AI system implementation to whoever you are selling to. And then finally, and this one is a quite interesting space, is the choosing of a retrieval augmented generation structure in order to reduce hallucinations by clearly referencing the databases that the AI draws the information from, right? Like a lot of research companies and also including Elsevier here in the Netherlands as a publisher, they are investing a lot of money in making this very accessible. So what that means is that at the end of the day, hospitals in particular and medical professionals, they have already existing databases full of information, full of data, and the RAG implementation essentially will draw the information only from those places, some from information that has been vetted, and try to represent as much as possible a clear, structured, referenced view in the output that can be very useful to doctors, a medical personnel in general.
Perfect. Thanks, Angus. Yes, very briefly, entry into force of the AI Act. It's already in force, but the most important part, the high-risk duties, they will start to apply from 2nd of August 2026. So now is the time to start being active regarding it. Also important to know is that if you're putting a final version of your product out before 2nd of August, and you will not change it anymore after, high-risk obligations will not apply to you. There is an exception which is important in this space, the ones that are sold to public institutions, used by public institutions, but outside of that space, you would be not subject if you're putting it on the market within the next 3 quarters of a year. Then, what do you need to do? You need to check whether the AI Act is even applicable. You need to obviously refrain from not doing prohibited stuff, like with many other things. You need to respect transparency and information requirements and try to train your people in AI literacy. If you're a high-risk system, you need to adopt proper risk management systems, data and governance policies, and produce technical documentations and instructions of use. Yeah, and the techniques mainly Angus mentioned before, definitely also good to implement. Yes, we still have 4 minutes and we can also probably make it a bit longer for questions. Also feel free to connect on LinkedIn or email us if you have anything that you don't want to share here. Yes, quickly to go through the stuff that is already in the chat. Synthetic data was a question. That is artificially generated, true. The problem very often is that it is trained on personal information first. So you need to create the synthetic data. And if that is not done properly, you might end up with just purely pseudonymized data, which still is personal. And that's why I say you need to be careful which provider you choose. In the end, you need to make sure that it's actually synthetic and not just better masked. Yes, if the person agrees to let their data be used, yes, this changes something. This is consent, but you have to be sure, A, that consent is retractable, so you can withdraw consent as an individual, which makes it sometimes a bit complex, especially when you're training models based on that data. And B, you need to really have it explicit and informed. So consent is usually the worst legal basis to base your training on.
I also want to add, it doesn't really change any of the obligations around how you handle that information on your end. You know, whether you can use it or cannot use it for whatever use case. But the regulation is very clear: consent or no consent. The data and the classification of the data does not change.
Yes. Then, does the EU AI Act apply to quality management systems that would be performed jointly with an AI-like decision-making process? Yes, this is then the thing as such is the AI system typically. So yes, this will apply as well in almost every case. I mean, you probably could design it in a way that you split the AI tool and the QMS, but yeah, would have to be looked at in detail. Successful collaborations between hospitals. So I know that the team at the Swiss AI Initiative is working on a health data model. There are also providers like Kaiko that work with hospitals on even like training personal data. But yeah, if anyone here in the chat knows of a in-depth tool that hospitals use that is public, I cannot say most of my customer stories because of the client attorney privilege. But if someone knows and can talk about this, happy to hear. What we did, for example, was a voice-to-text tool for a hospital already. Then we have advertisement for the next events. Also, thanks for this. I think cardio AI might be interesting. Health tech use and misuse, definitely interesting as well. I might tune into that one. Then the last question in the chat: how can any AI solution be EU health law compliant with it typically being deterministic? Yes. That's a good question, and also actually something that's still not really reflected in the current medical device regulation, for example. That's what I meant really in the beginning when I said that technological advancement is faster than legal advancement. This still needs to be checked in front of a court or with the regulator what threshold you have to fulfill. But yes, there are also deterministic models. You have, and there it starts to be a bit easier. You have discriminatory, not generative AI, or like discriminatory AI that simply assesses whether this CT scan includes cancer or not. There you have a bit. You usually can make it more reproducible. And then with generative AI, you can also design the solution in a way that it has less freedom to hallucinate. So what you often do is then splitting up, like chunking up the instructions. So instead of having one system prompt that defines together with the input, the output, you make a more rule-based tree decision structure where you have very, very narrow applications of each like model use of each run of the AI. And there you can be more deterministic. But yeah, this is still a bit an open topic that I honestly don't yet know how this will turn out. Over long term, I think it will just have to change. Like the regulatory environment will simply have to change. Yes. Do we have any other questions?
No, I think you have answered all of them.
Perfect.
Thanks very much. So I would propose that we close for today. It's good for you, Thomas and Aengus?
Thank you. Yeah, works for me.
Thank you very much for this deep dive of today. Yeah, I'm following the hand claps here. Thanks a lot. And for everybody who would like to watch it again, so you can check our YouTube channel and the session will be available there. So see you maybe on Wednesday. There's the next session for On Air. And thanks a lot to Thomas and Aengus. Bye-bye.
Thank you. Have a good day.
Ciao.
Thanks everyone.
Thank you, everyone.
Thank you. Bye-bye. Ciao.
Bye.